Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altishan, Director of Client Partnerships at Pacific Cascade Legal. And today I'm here with our lead attorney, Will Jones, to talk about dusting off your divorce decree and what to do if your divorce is out of date. So, Will, how you doing today?
Not too bad. We're starting to get a little change in the weather, getting a little bit warmer. Hoping to play some golf, but we'll see how that goes. Once the weekend gets here.
I love it. I am looking to plant. I am looking to put my lettuce in the garden this weekend. So that's what I'm going to do. But let's talk a little about, why it can sometimes be a good idea to go pull out your old divorce decree and take a look at it. And I know people are going to say, well, hold it. That thing is somewhere. I don't know where it is. I don't want to know where it is. I don't want to look at it ever again. But I mean, there are reasons, aren't there, that it might be a good idea to take a look at it. I mean, divorces don't expire, or do they?
No, generally no. So first off, I think it's kind of wise to, I guess, get settled in just a little bit on what we're talking about. Right. So you get a divorce, you end up with what's called a judgment, right? That basically says you guys are divorced. Here's your rights, here's your obligations, here's my rights, here's my obligations. It's all wrapped up into a judgment signed by the court that becomes kind of the law of the land. Custody, parent time, child support, spousal support, property division, all contained in there. So that judgment doesn't go away. You stay divorced. That's kind of the way it is. Some things in there can expire. Say spousal support was awarded for, say, 3 years. At the end of 3 years, unless it's modified, that's going to terminate. But the divorce stays in place. Property division conceptually is non-modifiable. So whoever got property or cars or whatever, that's going to be done with. But sometimes those things go out of date. So the judgment stays. And it's important to know that it's a judgment. It's an order of the court, and the court will enforce that if they're asked to, right? So sometimes it is important to go, hey, is there something in here that doesn't work anymore?
So let's talk about that a little bit. I think people don't necessarily know when it doesn't work. Let's kind of talk about a little couple examples of what kind of circumstances can arise, that can make a divorce decree need to be changed, modified, or at least talked about with your ex.
So a lot of things can happen, right? But it's important to understand that we're dealing with a judgment, right? So the typical one that you see 99% of the time, our parenting plan doesn't work. Okay, that's fine. Somebody got a new job, now they work weekends, and everybody works everything out most of the time. Most of the time, I don't have to get involved, right? I can't be there at 5. Can we just do pickup and drop off at 4? That's great and all well and good that people can get along well enough to have something else work out for them. But you have to understand the judgment is what's enforceable, not the new oral agreement. So we need to go back and we need to modify that judgment if we need to enforce it. But you can't go back and modify and enforce at the same time. So it gets a little tricky in that way. Typical things that make things go out of date or changes that come: new job, retirement, lost a job, parenting time has changed, income's gone way up or way down, um, physical health, health of a child, misconduct during parenting time. Um, Remarriage can also be in there, depending on exactly how that affects people. So a lot of these things have to do with modifying spousal or child support. Child support by itself can be modified by the state every couple of years, and they'll do a periodic check-in if you're using their services. So those are kind of some of the typical things that happen in life that could result in a change.
You were saying that the parents can't change the judgment. Um, but they can decide to change the judgment, can't they? If something's not working.
Yeah, exactly. So you have a judgment that sits out there and say it gives parenting time every Monday, right? Dad changes his job and now he's not free Monday. So now the parents just move it to Tuesday and everybody's fine. So mom decides, well, I don't like Tuesday. So now you don't get your parenting time. Dad has to go back to court and he can only enforce the judgment. And the judgment says Monday. So he's got a problem. If those two people came together and said, look, let's enter what's called a supplemental judgment, just like a general judgment, except it supplements that changes this parenting plan. It can both stipulate to that, although they do have to give some grounds. Here's why we're doing this, which becomes very relevant if you need to modify it again in the future. Why did you do this the first time? Now we know why. What are we doing now? If they would have entered a supplemental judgment, now dad can enforce his now Tuesday parenting time. So the parties can agree to that change. A lot of the times, because I'm an attorney, we don't see a whole lot of people who agree on everything. Every now and then, people will hire us just to draft documents because they've already agreed, which is a great idea. But oftentimes, as an attorney, obviously, we don't see a whole lot of people who are getting along just perfectly. So everybody can agree, but to make it legally enforceable, it has to be signed by the court. If not, what you have, even if the parties sign it and notarize it, notarization doesn't do anything, by the way. It doesn't change anything. But even if it's signed by the parties, what you have is a contract. It's not signed by the court. Because it's not signed by the court, you can't deal with all the enforcement stuff that the court has and or penalties because you have a contract. Now you have to sue under the contract, try to get damages. With parenting time, that's a wreck. So it needs to be signed by the court in order to make it legally enforceable.
Are there parts of a judgment that can, for want of another phrase, go away by themselves? And what I'm thinking is something like, let's say your decree says that support shall be paid until the spouse remarries, and the spouse remarries and looks at it and goes, "Oh my God, I got a call. I got to get this judgment changed now to show that the spouse's that support is over." Or is that, do they need to do that? I mean, can the sort of a decree automatically time out?
In some respects, it is possible. Going back to my earlier example, spousal support for 3 years. At the end of 3 years, that award automatically terminates. The judgment said so itself. It's important to note that just because support is terminated, the court doesn't know, and then by way of that, the judgment hasn't been satisfied, right? So even if you have spousal support that lasted 3 years, you paid it all. If you go to sell or buy a piece of real property, title companies are going to see that you owe spousal support. It hasn't been satisfied. No one has filed anything with the court to say this has all been paid and this is terminated. It's a little different than a modification, but the court still needs to know that to clear up that judgment record and say this judgment has been paid.
Yeah.
The automatic termination of things is always a little bit tricky because you end up in the we all know it's happened, and yes, it has happened, and we all agree it's happened, and the record, right? Because when a title company searches for judgments, they don't ask you anything. They go to the courthouse, they do it online these days, and go, is there a judgment here and has it been satisfied? Not, hey, let's call everybody and see if you paid this. Because we're talking about real property records and money judgments. So things can automatically terminate, but it's still important to go and clear up the record so you don't create problems in the future.
That makes complete sense. I tell the story of a insurance salesman who had a judgment. The judgment said that the death of the spouse, the other spouse does not get your insurance anymore, and the person who had that relied on it, got remarried, but didn't tell anybody or didn't do anything about it until that person died, and the old wife still got the money because just not because it didn't happen, but because no one knew it happened.
Yeah, and that's part, I mean, it's the same story,
Yeah.
exists in the same respect with the court record. If you don't have it written in a judgment, if the court record isn't clear, well, now you have something that can be enforced because that's what's in the court record, or can be terminated because that's what's in the court record. but no one has told the court that that's happened. No one has changed it. So what happens, say if somebody passes away, just like in your example, this beneficiary is listed right here. That's where it goes. We're not looking any further. Right. Same thing happens with judgments. I'll enforce what's in the judgment is what a judge will tell you, not what you guys have been doing forever.
Right.
Right. It's neat, but this is what I have to enforce.
Are there times when you look at your judgment and you're going, we're not doing this. We're kind of doing that. And especially kind of thinking more on the parenting time and that kind of stuff. Um, does that mean that they should automatically go in and somehow get the judgment changed? Or are there some levels of like, is it really worth it if we're not even sure we're doing this permanently? That kind of thing.
So I'll tell you that every good parenting plan that I've ever seen, and all the ones that we do, obviously, they say this residential schedule is for parents who can't otherwise agree. That's the first line of it. So the idea is hey, don't bring it to court if you guys are agreeing on something different, right? I have to work late Wednesday. Can you keep the kid Wednesday overnight? Don't go and modify the judgment for that Wednesday. It's not worth it. What's important for everybody to understand in the parenting plan is that's what's enforceable, right? So you guys are agreeing to whatever, everything's going fine, there's no problem. But if there is a problem, we as attorneys can only enforce what is inside of that parenting plan. So if you've completely deviated or done huge switches in things, or people have new jobs and new schedules and all that stuff, you have to know, look, we're going to go back to the default, right? You guys stop agreeing at some point. The default is the parenting plan, and that's the only thing I can enforce, not the new stuff that's happening, the old stuff that's in the parenting plan.
So there's no equitable estoppel, there's no latches, none of that happens in a divorce decree.
Conceptually, no, but there's special circumstances everywhere.
Yeah.
Equitable estoppel latches, things like that, for people who don't really follow the lingo that we use way too much here. Both equitable estoppel and latches are basically time defenses to things, where the classic one under equitable estoppel and kind of by latches is where an insurer says, look, we're going to pay you, we're going to pay you, we're going to pay you. Don't worry about it. Everything's fine. The statute of limitations on a claim runs, and then they go, no, we're not paying you. That's an example of equitable estoppel where the court's going to go, whoa, 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 you lied to them until the end of the statute of limitations. We're going to go ahead and extend that or toll that a little bit for you. That can happen in divorce decrees and enforcing them. The problem when you're dealing with enforcement is generally you're dealing with a term called contempt. Contempt is the willful violation of a court's order or judgment. So it's tough to prove a willful violation of a court order or judgment when the judgment tells you what you have to do, right? You're either doing what the judgment says or not. If you had a latches situation where, say, not as though I've ever seen this before, someone hasn't paid spousal support in 5 years and they want to go, latches, I haven't paid it 5 years. They haven't given me a hard time about it. I don't want to pay it. Well, we can still enforce that, right? It's a nice defense and a good try, but the court's going to go, no, there's a judgment and you're not following it. And it's clear you owe it. Plus, that deals with money. You can deal with collections, garnishments, and all that stuff. When you start talking about estoppel latches, that can happen, I suppose, in some property division issues or perhaps with interest or some very, very much more clear areas. But in parenting time, estoppel latches, there are some temporary orders we could deal with if you're in a modification, say like a status quo that can kind of lock in what's happened over the last 3 to 6 months. But that's a separate order and outside of enforcing. So you've got a couple different moving parts, but in a modification, there are temporary orders available. So there's some wiggle room, but there's still not enforcement, right? You're talking about a modification.
Right. And we've like in modification, and talking about looking at your divorce decree, it's probably pretty easy to find a change in circumstances that has occurred. And someone might say, oh, look, I'm making $185 a month less than I was, and they're making a little bit more than they were. or something like that. But that doesn't always necessarily mean, does it, that the modification will occur. There's rules as what you can modify and how you modify it, and what you need to show to modify it. Let's talk about that a little bit.
Yeah, so modifications in general. So one thing that we can't do unless there's some really special circumstances is we can't modify property division, right? That's solidified, it's over once the dissolution is done, right? So the judgment lays that out, it's over. We can reopen some cases if, say, somebody concealed something or forgot to put something in there. But generally, that's a closed book. It's done, right? What you can modify is child support, spousal support, parenting time, and custody. Those are always subject to modification. So when you're talking about a modification, let's look at spousal support first. You're talking a substantial and unanticipated change in circumstances, right? So that has a couple different terms in there that let you know when a modification might be possible. Substantial, unanticipated change in circumstances, right? So the kind of key component when you first look at this is substantial, right? If you go, well, I got $1,000 bonus last year, so I want to modify, or my ex-spouse got $1,000 bonus and they make 100,000 a year. I want to modify because I should get a little more because they got an extra $1,000 last year. The court's going to go, that's 1% of what that person makes. That's not substantial. Don't bring that to us. We need something more. The next one that we argue about all the time is unanticipated. What is unanticipated? That one turns exactly on what your judgment says and what the findings in the judgment were back then, right? So what's unanticipated? Is retirement unanticipated? Maybe. Kind of depends, I guess, on when it happens. If the judgment says nothing, then it's probably going to be a substantial change in circumstances that wasn't anticipated because the judgment's silent on it. If the original judgment said spousal support, $1,000 a month, retirement is anticipated at age 65, well, now you turn 65, you retire. That's not an unanticipated change. Judgment says it's not in, it is anticipated. So you lose out on that one. Substantial unanticipated change in circumstances. What that means is going to vary quite a bit depending on what's gone on. Child support is very much the same way. Substantial unanticipated change in financial circumstances. But you do get that DOJ, the state can review that if you're using their services for collection. So they'll kind of do a periodic review anyway. Same rules roughly apply, except for it's for the benefit of the child. So anytime you recalculate child support, you're looking for accurate income figures, right? So somebody gets a new job, loses a job, all that stuff. Substantial unanticipated change in financial circumstances, we recalculate child support, do the whole thing. Child and spousal support, they're separate from custody and parenting time. But to clear something up for people while we're still in the financial maze here, spousal and child support become judgments that are due generally on the first of the month, depending on what the judgment says. Some judgments say have to on the first, have to on the 15th. Once those are issued because the calendar rolls over, those are judgments and they're not modifiable as soon as they're due. They're collectible. Somebody can say we're satisfied here, right? We've paid what was due, but they're not modifiable. So they're still enforceable. So if you don't do a modification of child or spousal support, every time they come due, now that money is not modifiable. You can't change it now, not once it's due. So all modifications are prospective. So you want to make sure that if you are in that financial situation, you need to go ahead and deal with the modification before payments keep coming due, because I can't change them once they're due.
Right.
So that's modification of kind of financial stuff. Custody and parenting time. So parenting time is the easiest place to start, right? Parenting time is modifiable whenever it's in the best interest of the child, right? No hurdle. Is this best for the kid? Okay, we'll deal with the modification. That could be anything. Parent moves away, parent moves closer. Could work that way too. School change, kid goes to private school, kids having health issues. One of the parents has gotten heavy into heroin. Who knows what's going on here? But anything that is in the best interest of the child is a reason enough to modify parenting time. It gets a little bit more complex when you deal with custody. So we have a custodial parent. The court said, look, we think this is the better parent. Even if it's in the best interest of the child, the court won't change that. They want to know what's the substantial change to make me have to make this big of a switch. So just because it's in the best interest, which is parenting time, there has to be a substantial change first before we do something that dramatic. What's that going to look like? Really kind of depends on the case. Big chunk of that, which you see sometimes, is parents may have joint custody, right? Joint custody in Oregon only exists if both parents agree. So if one parent says, I don't want joint custody, the court cannot order it, right? It will not exist and the court has to pick one. So if you're going from joint custody to sole custody, the court has to pick somebody. You don't need that substantial change. You say, I don't agree with it, and the judge is going to have to pick somebody, or you're going to have to agree to it. So substantial change, best interest of the child. If you're dealing with finances, substantial and unanticipated change in financial circumstances. Those are your two big rules.
The brings up a question. Is the parents agreeing to something, or on the flip side, stopping agreeing on something, a substantial change? And what made me think of that is, if you've got joint custody and one of the parents 3 years later says, I don't agree on joint custody, is that considered a substantial change? Or, and the flip side maybe is that one parent has custody and now they're agreeing on joint custody. I mean, can that be enough to be the substantial change?
So you get a little bit interestingly technical, right? So generally to change custody, you need a substantial change, right? That's the rule. The problem is when you have joint custody, it only exists when the parents agree. So now the court has to pick somebody. So your substantial change rule is actually eaten up by the fact that joint custody only exists if they both agree. So now the court has to pick somebody. So you could consider that a substantial change, but really it's kind of two conflicting rules that exist.
Yeah.
Generally, if parents agree on something, whether it's one parent getting custody or what a parenting plan looks like, something like that, the courts go, yeah, that's fine, right? We're not going to kind of, generally, the court doesn't do this, but sometimes they do. The court's not going to go, look, you guys obviously are getting along well enough to draft your own parenting plan and agree on things. We're not going to substitute our judgment for yours. You're the parents. More often than not, when a judge has to make a determination, it's because the parents aren't agreeing, right? If everybody got along, well, the courthouse would be a lot smaller and I'd be out of a job. So pros and cons there. But if parents agree, yeah, the court's usually going to just sign off on it, unless there's something unbelievably weird there, some stress, something like that.
Yeah. You talked a little bit about enforcement and the contempt, which is like the hammer, and it made me kind of think. So you've dusted off your degree. It says that you're supposed to do this, and you go to yourself, "Oh God, I mean, I can't do that. I mean, just or just I can't comply right now." What can a person do if they look at it and go, I really can't comply to this degree?
Yeah, I mean, so if you're in the, say, unfortunate situation of not being able to afford your spouse's support payments, say, just to make that an easy example, you need to modify, right? Specifically, if you're looking at a long-term problem, right? You're 2 weeks between jobs and you're going to be back on it in 2 weeks and you'll pay off your arrearages. Maybe not worth your time. But you lost your job, you've been unemployed for 6 months, and you just ran out of savings. You need to modify. You just have to.
Yeah.
The, I guess, bad part, if you look at enforcement of some of that stuff, and I've been involved in, thankfully, on the prosecuting end of a lot of enforcement of non-payment and things like that, judges will say, because people will always say, look, I don't have the ability to comply. Like which is an affirmative defense to contempt. I do not have the ability to comply with my $500 a month spouse. I've raked people over the coals on that because a judge will tell you, and I've heard judges say, and I've asked the questions myself, you have a car, you have car insurance, you bought gas, you bought food, you've determined to do something else other than follow the courts, or if I'm the judge, my judgment, right? You're saying you have the inability to comply, but you're not even trying. You didn't pay nothing. You didn't pay $5 or $500. You paid zero and bought other things. So Judgments kind of take the cake when it comes to debts. They're as bad as you get in debts. They're enforceable, they're collectible, garnishment, all that stuff. So you should pay those first most of the time. Because they're judgments, you want to change them if you need to, because that's as bad as judgments get. That's as bad as debts get. So if you can't comply, you need to do something to get the judgment changed, or somebody's going to enforce that at some point. And it's going to be with interest, and you're probably going to end up paying attorney's fees.
Yep. Yep. And it got back, just swinging back to the last thing I wanted to ask, which we talked about a little bit, is if you know something is you're doing something different, or your spouse is doing something different and don't want that to happen, probably the worst thing you can do is just not do anything about it. Kind of wait it out to see if they get better, to see if the other person complains. I mean, because both sides, by waiting it out, have something to lose.
Exactly. Plus, you end up in a situation. Here's an example. Names redacted to protect the guilty and innocent. About 6, 7 years ago, I did contempt for a guy who hadn't done some stuff. Went to the hearing, judge ordered it, and the judge said $50 a day until this whole judgment is satisfied. So every day, $50 plus 9% interest. He still didn't do it. My client kind of ran out of gas and is like, I've had enough of this. It's not that big of a deal to me anymore. Don't do anything. So that's 6, 7 years ago, with a judgment out there holding him in contempt for $50 a day, plus 9% interest. I'm not even doing the math on that. 7 times 365 times 50 is what he owes according to the court record right now. Because he didn't go back and modify, because he didn't satisfy, because he didn't do those things. So if you're going to do something, you got to do it, and you got to get it done. And you have to understand that court records are going to follow. That's just the way it is. So if you need to make a change, you need to do something to get that change made.
I love it. I love it. Well, we just blew through 30 minutes, which is normal. And, so I really, again, want to thank you for being here, talking about why you should look at your divorce decree, not ignore your divorce decree, and, when it needs some change, how to get it changed. So thanks a lot. It was really very helpful.
You betcha, Steve. If anybody out there needs any help, obviously we're pretty easy to find and happy to help out.
I love it. And with that, thank you everyone else for joining us. And as Will said, if anyone has any other further questions on today's topic, you can post it here. We can get you in touch with us, and we can get you connected. You can give us a call. And until next time, stay safe, stay happy.